Here we go. Hello, good afternoon, good evening, good morning, wherever you are. This is Guy Christian with Goal 16 Podcast. Today's episode is going to have a focus on anti-corruption. Our guest today is Ms. Abiola Makinwa. She's a lecturer. She's a senior lecturer in commercial law with special focus on anti-corruption and policy at the Hague University of Applied Sciences in the Netherlands. She is also a lawyer from Nigeria. She has received some awards with respect to her work, and she has a book that is sold on Amazon. I believe it's a settlement of settlement on anti-corruption. I believe the title, but I will find it later. But please join me to welcome Dr. Abiola. Abiola, hi. How are you doing?
Very well, and thank you for having me. It is a pleasure to be with you.
Good. So if you allow me to ask you the first question, because I know you've written extensively on anti-corruption issues. So my first question is going to talk about extraterritorial jurisdiction, right? So I know the US is, the FCPA is something very concentrated and very based on extraterritorial jurisdiction. But I was wondering, you as a researcher, what do you think about that extraterritorial jurisdiction that the FCPA has? And do you think that it's something that could be applied by developing countries in their fight against corruption?
Thank you. Well, let us first start by just saying what FCPA means for benefit of our listeners who may not know.
Sure, they should know. Foreign, yeah, go ahead.
Yeah, so the FCPA stands for the Foreign Corrupt Practices Act. Okay. The key word here is foreign.
Yep.
You mentioned the word extraterritorial. Mm-hmm. This act deals with corruption that has occurred in the foreign land, foreign corrupt practices.
Yes.
How did we get this act? As you said, it is a United States act.
Mm-hmm.
This act was the first of its kind.
Yep.
The catalyst for this act was American politics.
Yep.
You may have heard, some of you who are old enough like me, about the Watergate scandal, when former President Nixon was up to certain things, and there was now an inquiry in the US Congress.
Mm-hmm.
They found out that companies were funding and donating money to politicians, and they wanted to find out more about it. And as they dug deeper, they now found that companies, as a routine business practice, were giving huge amounts in bribes in countries all over the globe.
Mm-hmm.
Highly placed politicians, and when I say highly, I mean highly,
mm-hmm.
so that they could get business. Now, this was not new. This is how they had always been doing business. But what was new was that this was an open hearing in front of the American people. So the American people, for the first time, heard about how their companies were giving bribes across the globe, and there was a huge outrage.
Mm-hmm.
And when there's outrage, politicians tend to respond to outrage. And the then President Jimmy Carter led this new, or brought this new bill, which was really the first time in the history of anything.
Mm-hmm.
You had a domestic jurisdiction, domestic court, the United States, giving itself jurisdiction over acts of bribery occurring in other countries. In other words, those countries where our US companies had given bribes, it didn't happen in the United States.
Mm-hmm.
The bribes were given in all over other countries.
Other countries, yes.
Normally outside the jurisdiction of the United States. They
Mm-hmm.
said, it doesn't matter where they gave those bribes.
Mm-hmm.
We have jurisdiction. That is a criminal act from henceforth.
Mm-hmm.
The Foreign Corrupt Practices Act, 1977 is not so long ago.
Mm-hmm.
Right? That was the first time Because normally, principles of international law, you cannot be interfering in another sovereign state's affairs.
Yeah.
This act not only interfered, it said we will have jurisdiction to make what is happening in that country a criminal offense.
Right.
And so that is the Foreign Corrupt Practices Act, which, as I said, criminalized giving of bribes to get business. The only problem, of course, I'm sure you can imagine, was that this was a US law that only applied to American companies. What about the Germans and the French? What about the Dutch? They didn't have any such restriction. They could continue giving bribes. Remember, if I may just slightly digress, giving bribes was routine. That is how multinationals did business. You may recall the OECD recommendation in respect of tax deductibles. Do you know that you could declare a bribe as a tax deductible?
Yep.
In those days.
Yeah, in those days, yeah.
Only in 1999 that they now had a recommendation that please stop allowing companies to declare the bribes they give abroad as tax deductibles. But that, I just want to say that for you to see how routine it was. All companies, not just the US companies, all companies were doing it. So the problem we now had with the FCPA, which was a US act only applying to US companies, was that they were now going to compete in the same market with the other countries with their hands tied behind the back. So one of two things had to happen. Either the FCPA was repealed or the FCPA applied to everyone.
Yep.
And to the benefit of the developing world, America had the economic clout, political clout, lobbied for about 25 years. It didn't happen overnight, but the rest is history. Today, that standard of criminalizing the act of giving a bribe to a foreign official, to a politician, to an elite, to somebody who can influence the granting of business in a foreign country, usually a developing country, was now a criminal offense. And we now have that standard repeated in the OAS, the Organization of American States, in the Council of Europe Convention, in the OECD Convention, in the AU Convention, in the United Nations Convention. So we now have a global adoption of this standard. It is criminal to give a bribe to get business in other countries. For the developing world, this had an immediate impact. It shifted the locus of prosecution from the demand side. You know, the person that takes the bribe is the demand side. You take the bribe. So the politician in Lagos, for example, just as an example, he was taking the bribe from let us say a Siemens or a Halliburton, or that is from the supply side. So you shift the locus of prosecution away from saying the courts in that poor demand side country that has been decimated by corruption, where the governance structures have been weakened, where the courts have been weakened by corruption. You say, look, we will prosecute on the supply side. So Foreign Corrupt Practices Act shifted the locus from the developing demand side, mainly developing country demand side, to the more, should we say, sophisticated and, you know, better, you know, I mean, well, let us say, systems that had a lot more capability and are more sophisticated, and the corporation suddenly had nowhere to hide.
Right.
Not just in the US, in the UK, in the Netherlands, in Germany, everywhere. Prosecutors on the supply side were now getting laws that told these companies that giving bribes is now criminal activity. So that was the beginning. This was the whole idea of extraterritorial jurisdiction. And for the OECD countries, they made it mandatory that every member state of the OECD must have laws criminalizing this foreign bribery, and they have done that. So that is what I would say about the extraterritorial effect and how it is a positive step for developing countries, shifting the locus so that it is no longer business as usual. Companies that give bribes suddenly have to come face to face with their own prosecuting authorities. It was a remarkable act, and we are benefiting from it, I think, in my opinion, in Africa today.
But do you think that African countries or developing countries on their own can implement such an extraterritorial jurisdiction, even though you may not have the same scenario you may have the same scenario in the sense that you are not going to have, since they are receiving at the end, because a company like Siemens is coming, for example, in Nigeria, Libya, or other countries in Africa to commit the act of corruption. But on the other hand, can these countries be able to prosecute these foreign companies for what they have done into their own country, meaning trying to reverse the process?
Okay, you ask a very important question. Very important question. You have the person who gives the bribe. You have the person who takes the bribe. Right. Both should be prosecuted. Abi, you should prosecute both sides if you want to stop.
Yes, it takes two to tango.
It takes two to tango. Yeah. And it is step by step. So now what we see on the supply side, now let's not forget from the definition I gave you.
Yes.
Foreign bribery is a supply side offense. Yes. Supply side, it is a crime, and they will that for the giver to give the bribe. Then and it doesn't really face the taker. Yeah. FCPA is a supply side offense. We shall punish the people that take the bribe. So that is on that side. But it's a very good point. Somebody takes the bribe. The OECD report of 2018, which said, let us see what happens on the demand side, found that even where companies were pursued on the supply side, even where companies reported themselves, maybe we will talk a little bit about.
Right. We will.
But essentially, the enforcement system is that companies go and report themselves to the authorities, and they say, this is what we have done, this is the bribe we gave, this is who we gave the bribe to, this is the channel by which we funneled this bribe money so we could get business. So all that information is in the hands of the prosecuting authorities in the South. So they know who took the bribe. The person who gave the bribe always knows who he gave the bribe to. You may not know the ultimate beneficial owner, but you can track it one step. You go through each gatekeeper, you will get there. Yeah. That report I referred to shows that there was very little prosecution on the demand side. Very, very little use of the information, very little transfer of information. Documents got lost. The court system was so slow. So the incentive on the demand side to cooperate with the authorities or to comply with the law is missing. In fact, one can say that it is a state of impunity because the systemic issues that they also had in the West, which led them to, I hope you will ask me about non-trial resolutions.
Yes, of course.
Big problems they had in effecting successful prosecution through the courts of law is we have it times 100 in the developing countries. We have it on both sides, but certainly it is exacerbated when you have poor governance structures and so on and so forth. So on that, I feel it is really very important that we develop incentives also on the demand side. And I have a couple of suggestions about how we can develop those incentives. But to your question, you need to punish not just the supply side. We need to develop mechanisms to encourage compliance on the demand side.
Right. Since you brought up the issue of settlement mechanism, within the context of anti-corruption. So the question that I'm going to ask you now concerns something that people have probably heard is DPA and NPA, Deferred Prosecution Agreement and the non-prosecutorial agreement. So I wanted to have your own opinion on that. If also developing countries could take advantage of such mechanism to resolve anti-corruption issues.
So there are two questions there. First of all, what are they? I can explain what they are. And then the second question is whether we can have a demand side response to this, which is a very good question as well. Now, what is a deferred prosecution agreement? What is a non-trial a non-trial resolution agreement? What is a non-prosecution agreement? What is a declination? All of these are agreements reached between the wrongdoing corporation and the prosecuting agency.
Right.
Why do we have them? Now, corruption in international business is challenging. To discover that it occurred at all. To discover that it occurred at all. Okay.
Yeah.
All right. Okay. I'm sorry. A bit of a distraction.
Yes.
So first of all, to discover that it occurred at all, because corruption doesn't occur in daylight, it occurs in secrecy.
Yep. Companies
will cook their books. They will hide the bribe as consultancy payments, as this, as that, as a charitable donation, as It is multi-jurisdictional across many countries. These are multinational corporations that are across the globe. It is multi-layered. You won't even know who to hold, to say this is the person that. So it's a very complex transaction. And right from the get-go, the US authorities in setting up their framework, just to make it simple, realized that they will not be able to effectively prosecute this new crime that they had created, foreign bribery, without having some inside info.
Yes.
Inside information. In other words, they needed to give an incentive to corporations, which are, after all they want to do is to make a profit and do business. They're not, they don't have a soul to be damned.
No soul.
Right. So you make the business case for them, they will flow with you with your business case. So the idea was to give them an incentive to cooperate. And the United Nations Convention also speaks to this, that we should develop mechanisms where companies will self-police, because the government acting by itself is limited. Have the capacity, even in the most developed countries, right? Discover these acts of bribery occurring, as I said, in these complex transactions. Not only do you self-police, you self-report. You go and report yourself to the authorities. Look, we're doing an audit and we found this and we have followed it up, and this is what and we're coming to you with this information. Information that the prosecutor would not have found on his own. Not only that, these are the steps we took to remediate when we found out, and we came to you as fast as we could. If you have those elements in place, you can begin a discussion, but that is not all. The way the system is structured, you cannot reward bad behavior, and you cannot reward companies that are, trying to, should I say, scam the system. You want to reward good companies. You want to have companies that have good systems, good internal controls, good compliance processes, good training, top level commitment, all the way to the top. Everyone is committed to a zero tolerance bribery policy. You want to have companies that are robust with good whistleblower systems. You want to have companies that have good communication. So everybody in their supply chain, everybody in their sphere of influence knows that this is the policy of the company and this is how we are going to engage with this. Right. And you want those kind of companies, and the company, before they can enter into a deferred prosecution agreement, non-prosecution agreement, declination, has to show that, look, we did all that we could, and here is the proof. All these things I have said are very demanding processes. You have to identify, you have to remediate, you have to monitor, you have to review in a PDCA cycle. If you think, when did you start hearing about compliance departments in multinational corporations? 10 years, maybe. I think Walmart appointed its first chief compliance officer. We didn't have such a thing before. It was about 7 years ago. So the carrot of, if you come to us with all these things I have mentioned, and you prove to us that you had all these things in place, and still somewhere, somehow, in one agent somewhere engaged in this act, we can negotiate what the final penalty will be. If you can And there's a whole range. We may decide to decline to prosecute you because we can see that this company truly did its best. We have to be careful that companies get very good guidelines. And this is where the US has improved, and the UK and France. If you look at the guidelines of what they expect to see, they are becoming clearer, more specific, and they're encouraging companies to take certain steps. So they are changing the behavior of companies and changing the internal culture of companies and changing all the people that the companies engage with, all the employees, all the suppliers, agents. So this is a bottom-up approach to changing the transacting environment. If you can show all those things, they may defer the prosecution. In other words, they will they will say, if you behave well for 4 years, we will monitor you. Maybe sometimes they will apply a monitor, and indeed all the things that, because obviously something went wrong. That's why, they found out bribery occurred somewhere.
Right.
So you now have like a probation period. If in that probation period, you go from better to excellent, you drop the charges. If in that probation period, you do it again, or then you will face the consequences, and they can go ahead and prosecute. So it defers the prosecution in some instance. In some instance, they will reach a non-prosecution agreement because they have seen the efforts the company has made, or a declination. So what does this do that is beneficial to African countries? Everything I've described shows that the company has to take preventative steps and structurally set up a mechanism to find out before other people find out.
Yep.
Think about it this way. You and I have a company. And we are in the same sector. We're doing the same business. I know what you do. You know what I do. And something happens. There's a flag. I go to the US authorities and I say, Makinwa Company and Co. We are reporting ourselves. But meanwhile, Mr. Apple's company is doing the same thing.
Yep.
You know that you have lost out on your negotiating advantage.
Yep, of course.
The first person to report gets the best deal. So there's also a kind of peer pressure, if you can call it that. So you need to have good systems in place to be able to take full advantage of this process, which is why we have compliance departments now, which is why we have compliance officers, which is why we have companies taking a risk-based approach to assessing their bribery risk and making sure that they can motivate to a prosecutor if things go wrong. Remember, all of these things they have to put in place before, and this is the beauty for developing countries, before any act of bribery has occurred, before there's been any discovery by any prosecutor of anything, we're not even talking about a court case. They are motivated in their own self-interest to put in place measures to prevent acts of bribery from occurring. So we move from this notion of punishment after the fact, after the bribe has been given, after the corrupt contract has been awarded, when you now be mopping up the water that has spilled. Now you just shut the tap. You shut the tap and you prevent the water from spilling in the first place. The benefit to the countries that suffer the consequences, I'm sure you can see that prevention is better than the cure. When we were talking earlier, I gave you the OECD example.
Yes.
A company gives a $1 million bribe, and you now be prosecuting the company for $1 million bribe.
Yes.
But that bribe, the damage it will cause, this is an OECD example, can be up to 100 million worth of damages in terms of poor governance, in terms of undermining the structures, in terms of facilitating illicit financial flows, in terms of, perpetuating that vicious cycle of corruption.
Right.
So for us to be able to mitigate the damage caused by corruption, we need to go beyond punishment to prevention. And I think this is one of the things that we find in this new approach, public-private cooperation, self-reporting, and changing how companies behave, that speak to corruption prevention, which I think is definitely to the benefit of developing countries. That was the first question. I hope I'm not speaking for too long.
No, go ahead.
So the second question was, what about the demand side? Can we not create similar incentives? what will make people report themselves to the authorities on the demand side? I think that is what we need to think about, as opposed to saying courts, judicial reform here. It's all important. I'm not saying it's not important, don't get me wrong. Mm-hmm. But we should also think creatively. What would make people go and self-report themselves to say, come on, this is what I did. These are the channels. This is how it happened. I'm ready. I want to talk. Yeah. What can make that happen? And I look at some of the initiatives, the Kleptocracy Act, mm-hmm. the United States, the Magnitsky Act, the UK recently passed its own global, what do those acts do? Essentially, they seize people's assets abroad. Mm-hmm. So if you have money in the United States or in the UK zone is even global, they can freeze your assets. And I think that is an interesting principle that we can also apply. Let's just think together. We can also apply in this circumstance. For example, company A goes to self-report to UK authorities and says, this is the person I gave the bribe to on developing country B side. Mm-hmm. The facilitator, because as I say, very rarely would you actually give a bribe directly to a politician. There are all sorts of structures that they use that are used. But the bribe giver always knows who the bribe taker was. Yep. All you need is the gatekeeper or the facilitator, just the name, just a few names. And then an idea, just an idea. Remember, this is evidence which meets a certain threshold for it to be accepted by the prosecuting authorities on the supply side. So this is evidence that meets that threshold. We can now draw on this kind of Magnitsky sort of principles. Mm-hmm. You should not have an automatic bribery block for all the assets in the jurisdiction of that prosecutor associated with the names that have come up with evidence. They too can do, that there's evidence of that these are the people that took the bribe. Mm-hmm. I may even go so far as to suggest that kind of block, to create the incentive to really incentivize it, you say this block also applies to right of entry. No visa will be granted. Mm-hmm. Not just to the person that took the bribe, but let us just say to the family. No visas will be granted, let us say, even for medical care, even for schooling. Because what happens, let's look at this governance situation. Mm. One of the reasons that we have no schools, or where we have schools, but we have challenges in our infrastructure. We have challenges with our hospitals, with our roads. Mm-hmm. We have challenges with our universities. Mm-hmm. Because you send your children abroad, you go for a medical checkup abroad. Right. The incentive to make sure that you fix your hospitals is kind of reduced. Yeah. With pandemic now, people are realizing that it's good to have hospitals in your own country because,
Yeah, definitely.
What happens when you have this kind of incentive creating exercise by like an anti-bribery, the lines we have discussed, is that, first of all, you catch the attention of the people whose attention you need to catch, because they will now feel compelled to come to you to try and remedy the situation. You will now have an incentive for people to come forward and say, let me use myself as an example. I'm a lawyer. Maybe I facilitated a bribe to a certain charity which belongs to certain somebody, okay? Yeah. I was, look, this is the role I played. This is what I did, etc., etc. And depending on the level of cooperation, the block may be resoftened, the block may be removed, but I now have an incentive to cooperate. I am willing to give information, I'm willing to give evidence, I'm willing to give receipts, I'm willing to give the prosecutors whatever they need that I have. And then they move on to the next person from the information I have given. This is about incentives. So to your question, what should we be doing on the bribery side? Yeah. On the demand side, we should be creating incentives for cooperation. And I think that the lessons that we learn, or when we look at the what is happening on the supply side,
Mm-hmm.
we can now link those two things together. Where you have challenges in governance, even this system I have suggested is open to bribery itself. You just bribe the prosecutors now, I mean. So what you now need to do is to link the demand and the supply side together.
Mm-hmm.
Whatever agreement is reached has to be approved or sanctioned or by all the stakeholders. Who are the stakeholders? The prosecutors that gave you the information in the first place. Supply side.
Mm-hmm.
You know, so that way, after all, the block is on the supply side, it's not on the demand side. So there should be a way of meeting a threshold, and I think that will also be a check against such a process becoming another vehicle of corruption and impunity. So this is just an idea of how to show that, you know, it is possible to leverage this type of cooperation, self-reporting, putting in place hard and soft controls. Because you see, once you create that incentive, a lot of other things will now fall into place. When I was doing my Ph.D. research, something struck me in some of the interviews I held when I was listening back to the recordings. One company CEO who I was discussing this issue with, he said that at the end of the day, when we want to be able to do business with the Americans, and therefore we need to pass their due diligence, and therefore we need to have certain things in order for us to pass their due diligence. Mm-hmm. And that struck me. This CEO, he didn't know anything about FCPA.
Right.
He didn't know about any international regulatory framework. Out of self-interest, he was saying, I need to pass due diligence. Now, due diligence requirements are part of the requirements that are required for deferred prosecution agreements and so on. So now everybody knows about due diligence because all companies must do it as part of this establishing that they took all the steps they could take to make sure corruption did not occur. Right. But here I was just listening to this CEO and I said, this is how you fight corruption. When people out of self-interest are taking certain steps, putting certain things in place, putting mechanisms in place, and then you can now build a whole structure around that. As we see, that is what is happening in the Western countries, essentially the supply side countries, where they are refining this negotiated settlement process. More and more countries, you mentioned them, there's a whole list of them. Australia is now trying to develop its own. The South Mexico, Brazil, they all have, more and more countries are taking this pragmatic mechanism because it is producing results. Right. Companies are also, working along with governments. Companies are changing the way they run their internal affairs because of these requirements. So I hope this gives just an idea of how we can learn lessons from this experience. It's a quite young experience. This is an emerging, the UK Bribery Act was 2010, not so long ago. The UK Deferred Prosecution Agreement process was 2014. Mm-hmm. So it's quite young. Australia is still writing its own law as we speak.
That's correct.
It is a trend that is not being reversed because it overcomes many of the systemic problems that you face in the traditional criminal prosecution process. And I actually feel that this will now augment the traditional criminal prosecution process, where you see disclosures can be used to prosecute individuals. Right. In the Una oil case just last week, two of the managers, this was a UK case, Una oil was a huge bribery issue all over the world. But now, 4 or 5 years ago, we had deferred prosecution agreements being entered into. When you hear deferred prosecution agreements, of course, you know that information has been given, plenty. And now we're seeing individuals being prosecuted. It's not easy to get, to establish the locus of responsibility sometimes in these complex things. So it's in fairness to the prosecuting authorities who sometimes may dismiss cases against individuals. We have seen that happen more than once. in these multi-layered complex transactions to establish the individual guilt can be problematic. But we see that in the Unile case, just last week, I believe it was, they announced two convictions, of parties who have been management who have been involved in some of these bribery schemes. So deferred prosecution agreements, settlements can actually augment and help the judicial process itself to become more effective.
Right.
Properly used. I hope that answers.
No, it does. It does, definitely. It does. Thank you. Now, let's talk about arbitration and anti-corruption. As you know, many countries from the developing world are fighting arbitration cases all over the world, in all courts, sort of courts. My question to you was, what can these countries do? Because it's very difficult. You came to power. The former government that was there before you signed these agreements, under questionable conditions. And here you are. You have this agreement with you. The other party is looking forward to enforce them, but the condition does not allow you. Maybe there was some corruption in, maybe there were not. But in other words, we know that in many negotiations between these parties and our government in developing countries, there is always this possibility, 99% of the time, where people took some bribes before they appose their signatures on this document. So what can these countries do?
So this is a very challenging aspect of anti-bribery enforcement.
Right.
The bribe is a means to an end. It's never the end in itself. So when a bribe is successfully given, there will be a contract. That was the whole point of the bribe in the first place. So from a legal perspective, you cannot have a legal act built on an illegal act, all right? That is the principle.
Yep, I agree.
So these are contracts that are tainted by an original illegal act. So in principle, we should be able to sue, and there are some cases. I wrote a book, Private Remedies for Corruption, my PhD thesis.
That's the book I was mentioning. Thank you for reminding me of the title. Yes.
On how we should be able to challenge the two sets of contracts that emerge from giving a bribe. There's if I give a bribe to you to get a contract, the agreement between myself and your good self is a contract. That is it. It is a contract to give a bribe from me to you. The contract I now got through your influencing, the procurement contract, the public contract I got, is the result of this successful giving and taking of a bribe on, so we can call that the secondary contract that results from the primary contract. That contract is founded in immorality, it is founded in illegality, and it should be null and void in itself. So we need to have more cases that challenge the resulting contracts. So that is the first thing. World duty free, we should look at the case. World duty free, this was a case where that principle was upheld. Anyway, the challenge that we have is, and I think this is the conundrum about prosecuting corporations. I tell my students that the fact is we need healthy companies.
Yep.
Do you remember Arthur Andersen? Arthur Andersen used to be a big company. Remember Arthur Andersen? You remember what happened to Arthur Andersen?
Yeah.
Yes, corporate death. It died.
Yep.
Because of, now I'm just saying that, let's just say this is the flip side.
Right.
When you punish a company, who are you punishing? You're punishing the employees. You're punishing the shareholders. You're punishing the consumers. You may even be punishing the economy. All right. So on the one hand, you hear me say we should make sure that these corrupt, illegal contracts that are tainted by illegality, we should develop the jurisprudence and we should go after these contracts on the one hand. On the second hand, we also have to say, is that the most effective mechanism to redress this issue? Because at the end of the day, we may feel very happy when we have, you can't jail a corporation. You cannot jail a corporation. So who is going to, who are the innocent bystanders? How many of them do we need before we feel happy that we have, that the company has suffered, or maybe we want the company to suffer a corporate death? So that is, and that doesn't help anybody's economy. So that is a challenge. What we need is to get companies to change their behavior. And this is where we go back to what we were discussing before. Yeah. A healthy company, free and fair competition, is building our country, providing jobs, especially in this COVID pandemic era. We are going to go into a very, very difficult economic situation. We need robust and resilient corporations. We need corporations that are not being eaten from the inside by corruption. So we need them to work as effective machines to promote the growth of our economy, to promote our well-being. So we have the first step is a good step. We now have these companies self-reporting and putting in place hard and soft controls to stop us of corruption from occurring. The next step is to, and I want to go back to your question, is to also raise the threshold, the risk level. You know, it's about incentives. Those secondary contracts should now be, I think we need to pay more attention to the fact that these have emanated out of illegality. Having said that, I also have to be realistic. I mean, the rule of law is the rule of law. We also need companies to function and so on and so forth, but that is the underlying principle. And that is why I think I have been quite, I've written a bit in this area about the potential of negotiated non-trial resolutions, negotiated settlements.
Right.
I think I'm trying to show that there are some systemic issues that need systemic answers. Yeah. We need to change the way the system is functioning. So here again is a possibility. Then we can look at punishment in a different way. Punishment does not necessarily have to be a fine. It doesn't necessarily have to be putting somebody that you cannot put the company in jail anyway. I recall the settlement that was reached between Siemens and the World Bank. It's public information, I can discuss this. They entered into a non-trial resolution, let us say a non-trial resolution.
For
the bribery that Siemens had engaged in.
Okay.
In the tune of $100 million. And what was it? They couldn't identify a particular victim, but they created an integrity fund, which has been used to fund a lot of good work by civil society, a lot of anti-corruption initiatives.
Right.
Has really pushed the fight against corruption forward. Abigail Bellows in the United States has also made a suggestion, and I know there's a bill now working its way through the US system, which says that anytime a company enters into a settlement, there will be a matching, not a matching, there will be an additional line item that will be included in the settlement. $5 million that will be paid into an anti-corruption fund. The anti-corruption fund will be used to help fund anti-corruption initiatives. Again, you are thinking about the public interest, about helping the victims. I mentioned the beneficiary. Did I mention the third-party beneficiary clauses in this?
No.
No? In my own work, I gave some, maybe it's too detailed to go into now, but I gave an example of how the ultimate victims, when you say you're going to give a public contract to build a hospital, the hospital never gets built. The people of the area that would have been served by the hospital are the victims of that corruption that led to the hospital never being built. Those people have a right to any dispute or settlement arising out of that contract. And I explain in my paper how you can use third-party beneficiary clauses to give those ultimate victims a local standing to be a party to whatever settlement comes out of that transaction. And this is important because some countries now are including as one of the requirements for a deferred prosecution agreement. If you look at the rules in the United Kingdom, look at the recent rules in France, they make express stipulation that victims should be compensated.
Yeah.
Right there, as part of the discussion that the company that is reporting itself, by the way, will have with the prosecuting authorities. The company has the onus to show that it has tried to find the victims, to compensate the victims, but here civil society must, and the courts must play a very important role. If these kind of very useful and good provisions are not to become a dead letter, they must be monitored and they must, be developed. Because let us say, okay, the Siemens settlement, $100 million sounds like a lot of money, but who decided that amount? Who represented the victims when they were deciding $100 million? Maybe it should have been 200. Maybe it should have been, 150. Who decided that? So we need to have mechanisms. Civil society needs to get engaged to make these provisions come to life. I was recently part of what we call the drafting of the Hague Business and Human Rights Rules, precisely for this kind of situation, where you have a set of arbitration rules that address equality at arms.
Right.
You know that if you want to bring a case and on the other side is Siemens, that's a problem. There is no equality at arms, and we need to have a framework within which such victims of human rights abuses can enter into arbitration with these in these kind of circumstances. For example, how do you determine the level of compensation? Yeah, you need to have a framework around which the interests of the victims are taken into place. So that is another very good initiative, but all of these go to show how you can look at things from a corruption prevention perspective. It's already happening. And the settlements regime, there are criticisms, and I'm not saying it's a perfect regime. Remember, this is a young emerging regime, so there's work to be done.
Right.
I believe the courts should play a role in ensuring that the public interest is upheld, that these mechanisms do not become vehicles for impunity in themselves. But let us call a spade a spade. The only way you can appreciate what is happening is to look back 15 years. You don't have to look back far. How much enforcement was going on?
Right.
A good example was France. I can mention it as public knowledge. France had very beautiful anti-corruption laws, just like we have very beautiful anti-corruption laws in Nigeria. The OECD said, look, how is it that for almost 20 years you have had good laws, the laws have been improved, in fact, they've recently added more, bigger, better anti-corruption laws, and no prosecution? So this is the problem of political will, where governments are not willing to take action against their own companies because they have, obviously we all need our companies. So what the FCPA does is two things. It's extraterritorial jurisdiction. So even if France doesn't want to act, the US can act and take those same companies to court. So what we found is that all the French companies and the French, this is all public knowledge, so I can say it, but all these companies that were not prosecuted by the France were taken to task in the UK. BAE inquiry, do you remember that, Tony Blair? When they dropped the investigation for security reasons. The UK dropped it, but the UK picked it up.
Yep.
So when you deterritorialize the localized prosecution, you suddenly start to feel the cracks that wrongdoers can hide in. So that is a very important aspect of this of this issue. So anyway, so that is to the question of arbitration of contracts tainted by corruption and how we can review what we how we can structure, I'll put punishment in quotes, in a way that can benefit the public interest, that can benefit corruption prevention. And there's one last thing I will say.
Mm-hmm.
When you create proper incentives, let's for example, when I was doing my research, someone said something which I found very interesting. We had an amazing champion of anti-corruption, Ribadu, in Nigeria,
mm-hmm.
a while back. I remember, so at that time, 10 something years ago now, there was a period of time when things were really hot. I think when Ribadu just started, things were really hot. And people were afraid to send their money abroad. They were afraid because there was good cooperation. This North-South cooperation is so important because it created an incentive. But this came up in an interview with someone. He said, the thing is, what are you going to do with this money that you cannot send abroad like you normally do? You can't sleep with it under your pillow.
Mm-hmm.
We're talking about huge amounts of money.
Yeah.
So that money was now contained within Nigeria. He said that the stock market rose.
Mm.
People had to invest that money in the economy.
Yeah.
So this kind of containment, you can think of strategies. If you can just keep the money within the economy that needs it, it will have. So again, instead of saying punishment, let's find a way to keep the money from leaving. Let's have North-South cooperation and block the money in the economy. How about that? You'll be surprised that the benefits to the economy and therefore to the ordinary citizen.
Yeah.
How much did we benefit from Abacha's millions? We're still, you know what I mean? It's very nice.
Definitely.
But let's talk about structural change, structural steps that will actually change the way people operate. So that's another way to think about punishment and international contracts and what happens with arbitration. I'm just giving you a slightly different perspective here.
I appreciate that. So, now, let's talk about, if you don't mind, let's talk about the issue of stolen asset recovery. You suggested that stolen asset recovery should not be mixed with corruption settlement. Could you explain?
So, asset recovery is a very important principle of the United Nations Convention Against Corruption. Stolen assets should be returned.
Mm-hmm.
Stolen assets, stolen properties that belong to citizens should be returned. That is a fundamental principle, and I'm 100% in support of that fundamental principle. Now, what I think is important in this discourse is that what we have seen, and we speak about the damages gap. What are we referring to? The latest settlement with Airbus.
Right.
You know how much the settlement was for? It was $2.9 billion dollars. Siemens was 800 million. Halliburton in Nigeria was 579 million. So you hear these big sums of
money.
Mm-hmm. Where is this money going? It's going to treasuries on the supply side.
Yep.
The damage that these huge flows of money is causing is happening on the demand side.
Yep.
So there is a gap between the countries that are receiving these huge amounts of money and the countries where the damage has occurred, these monies are not received. But these monies are not assets. And I think, let us be clear, they are monetary, they are fines, they are sanctions, they are penalties imposed by a sovereign state based on the fact that its laws have been broken.
Yeah.
And the fact the higher the penalty, the better for the developing country, because you are punishing their grievous conduct. So that is not the asset recovery that I think that so you cannot recover what is not yours. That property is not your property. But, and this goes back to some of the things I mentioned earlier, I think it is very important that the damage that is caused by these huge flows of illicit funds to undermine governance, to encourage politicians to abuse their office, that damage should be part of the non-trial resolutions dialogue. And when you're arriving at a settlement, you can agree to whatever you want to agree to. After all, it is an agreement. And that is where we find, and I gave you a couple of examples, how you can identify a group of people, how you can have it just as, as a line item. If you cannot find a group of people, you say this money will go to an anti-corruption fund. You can introduce a compensation for damage. And what I like about this is that it gives the act of foreign bribery a human face.
Yeah.
It makes the company, the victims, more aware of what is going on. That in itself is another deterrent against acting, engaging in foreign bribery, because it's no longer anonymous. You de-anonymize this transaction. And I think I really commend the laws of the UK, the laws of France, where it is explicitly stated, victims' compensation. That provision should become
universal,
a standard.
Yeah, standard.
In all of these regimes. Every time there's a settlement, civil society should be looking and making sure that there has been compensation to victims. If you cannot find any, you put the money into a fund. And as I said, there's the Crooks Act. There's a very impressive proposal that is going through the Congress by Abigail Bellows, I believe her name is, and that is to be highly recommended. So, but this is all about creative thinking, and that way you can make the system work for the common man.
Yeah.
The system that we have now, let us call a spade a spade.
Yeah.
We have been shouting and shouting and shouting about enforcement. I think you were saying, how can we get the people on the demand side to have compliance and this? We shouldn't be begging anybody.
Yeah.
You have to create the right incentives. And I think that is the lesson that we find about what has been happening. It's a very pragmatic approach. It is a house that needs to be built. This is just the foundation.
Yep.
It needs to be fine-tuned. It needs to be, there are areas that need to be carefully looked at, because now everybody's jumping on the bandwagon. You have, imagine that your company is a multinational. Of course, you operate across many countries. And instead of one country, you have 6 countries that are chasing you. Now, okay, one can say that from the deterrent side, it doesn't matter. Let there be 100 countries chasing the company. But you have to have a system that is sustainable. So now that more and more countries are getting involved in this pragmatic non-trial resolution, they have to start speaking to each other, and they are. So you now have global settlements where they agree with each other how they are going to, should we say, share the pie of settlements, so that you don't kill the goose. You cannot kill the goose that lays the golden egg, because that golden egg, we need it for our economy.
Right. Now, let me let me ask you a last question about still within the stolen asset recovery area. People who have pushed back, other experts have pushed back, trying to justify why some countries are not returning the asset where the asset was taken from. A good example is public record, is the case of Equatorial Guinea. They still have those $30 million for the property, out of the proceed, which are the proceed of the sale of the house of the vice president, who is the son of the current president. And so they have said, look, this guy is still in power. He stole the money to bring it over here. We have seized it. We cannot return him to them because the guy is still there. He's still going to take the money and do the same thing. But he's going to go buy a property in a different country that does not have the same enforcement capabilities that the US has. So what do you say to those who say, because this is clearly in violation of UNCAC, what do you say to those? people.
So I'm just trying to remember the name of the country where monies were returned,
Right.
but into a structure that was set up to make sure that the money would reach the people of, was it Azerbaijan? Right. I have to check.
No, in this specific case, they had an agreement with the Department of Justice, where the current vice president still has, he has a word. I mean, he still can say he does not agree with what the Department of Justice did. Because the Department of Justice asked them to find NGOs that are providing help in Equatorial Guinea, to Equatorial Guinea. And the reason why I'm telling you that is because I was the one who proposed that resolution. At the time, I was the legal advisor.
All right.
So I said, the US is not going to stop coming after you if you don't give up this asset. The best way to do it, because I already have some informal discussion with some DOJ officials, and we came, well, if your client, not my client, but if the guy from the country, because I was working for their country, accept, we may actually get to do that way. But their fear is now that the same NGOs that were identified were, if you want, created by the same vice president or his cronies to be able to get that money back. So that's what the US said, you know what, we are not going to give the money back unless there is a change of regime. And the new regime will have access to that, to the $30 million plus interest. They are kept into a special account overlooked by the Treasury Department.
So this is the fundamental problem. Corruption fights back. You can, the structures, work structures have been compromised, and I think this is important. Let's just be, we can be looking at the law, we can be quoting law, okay? But where structures are compromised, we have to find ways to bypass compromised structures.
Right.
And all the things that we've been discussing is all about bypassing a compromised structure, but we were discussing it in terms of foreign bribery and prosecuting foreign bribery and all the systemic issues and how we have found actually these are workarounds so that we can actually have the rule of law, because the rule of law is not enforced when you have impunity. Only the actual enforcement of anti-bribery gives the rule of law. So we cannot be pointing to the courts, and we cannot be pointing to the letter of the law. And I think this is where, when it comes to asset returns, we have to also, in a similar way to foreign bribery investigation and prosecution, look for mechanisms where you can have checks and controls. What I suggested to you about how we can link back demand side and supply side non-trial. I said that it's not enough to just say, okay, you can have demand side non-trial resolutions. That can also become corrupt because the system is already compromised. But if you link it with the supply side mechanisms, then you can have a check and a balance. So we're looking for a smart environment. When you create this smart environment with asset recovery, for example, what is the logic in giving stolen funds back into why would you want to fulfill the letter of the law and compound the issue? So I think in this area of asset recovery, it's very important that these funds should be aggressively challenged. I think seizing and forfeiture is also a very positive step. The step that now has be looked at squarely is, can we develop mechanisms to use these seized assets that still fall within the spirit of UNCAC, the spirit of UNCAC, or the spirit of asset recovery? Because when you look in Africa and you see schools and you see hospitals and you see universities, come on, I think we can also be creative about creating channels of asset return.
Yeah.
Without holding to the letter of the law to what end. So that's what I would say about that. I'm not saying that it is not important to respect the rule of law, but we should also be able to use, to realize the spirit of the rule of law in the mechanisms we come up with.
Well, Dr. Abiola, this was a fascinating, certainly lengthy, but is it in deep conversation about anti-corruption and different processes and mechanisms. And I hope the audience will enjoy it, especially your student. They should, because this is where they see experts like you and I discuss about these issues, where we find a common ground to what international organization or the international community should be doing. So for that, I thank you for your participation, for accepting to participate in this conversation. And I know we will continue to discuss, off the air and during our meetings with the faculty panels and other panels where we are so valuable contributors. So I wish you a happy weekend, the best, and I look forward to speaking to you again. Thank you so much.
And please let me say thank you to you for this very admirable initiative and this podcast series. It's been a very great pleasure to meet you and to be able to share these words with you. Thank you very much.
Thank you very much.